And I'll make a motion that we adjourn the public comment portion of the hearing.
Second.
Motion's been made and seconded. All those in favor? Aye. Any abstentions? Okay. Motion carries. At this point, we can...
explanation statement then. Because we close the meeting. I need this. I need to just explain what's going on with this. I just want you want me to just read it? If I may, just to make clear the extent of the court's order, on Friday there was a hearing on an injunction request by Springwood to restrict voting on the petition, that is the other ordinance that was had been advertised for tonight. And the court on March 7th entered the following order, and I'll just read it if you could bear with me, and this is so you'll understand why Mr. Kelly was reluctant to participate in some of the discussion tonight, and maybe needs to refrain from participating in certain issues before the board for the time being. Now, to wit, March 7th, 2008, after hearing and in consideration of the testimony produced and the arguments of counsel, it is hereby ordered that the motions to dismiss complaint and quash filed by the defendants are denied. The court finds that plaintiff is without an adequate remedy at law, and that the plaintiff will suffer irreparable harm if a preliminary injunction is not issued. Accordingly, plaintiff's motion for a preliminary injunction is granted, and it is ordered as follows. Number one, the defendant board of supervisors is preliminarily enjoined until further order of court from considering or holding a hearing on the rezoning petition. Number two, defendant Michael Kip Kelly is preliminarily enjoined until further order of court from participating in any action involving or affecting Springwood or the Springwood property. Number three, Springwood shall post a bond acceptable to the court in the amount of $5,000 or the cost of advertising, whichever is greater, and correspondence I received today indicates that such bond was posted. And I'm not sure where we are on the agenda.
Well, at this point, I think we need to discuss the motion, the amendment itself. Just 2 points that I feel I need to make. First, there's been a lot of discussion. Obviously, I was a party to all the meetings that occurred over the course of the last 2 years that Mr. Ebersol alluded to. I suppose that I am an educator, and if it took 2 years to get my students to where they need to be to actually consider something, then education in America would be pretty much ground to a halt. Thankfully, that's not the case. But in 2 years, we finally did get an amendment that was proposed by our planner. I did ask that Ms. Cleary take a look at that amendment, and she did, and she made some suggestions and some changes to make it things that she felt would make it more legally defensible, I guess, and cleaned it up. There were a lot of good things that were mentioned here tonight. TDRs are a great thing, but I think it's been made abundantly clear to me by all the planners that I've talked to, including Mr. Schmale, that it's not a feasible thing to do at the municipal level, at the level of a single municipality. I think Mr. Meyer would agree that in order to go that route, you're looking at a multiple municipal planning agency. That takes time, and I've not seen anything from any of the other municipalities that indicates that they're actually interested in going that route. I hope that they are. I think it would be a good thing. I think we could all benefit from one another. So I'd like to say, and certainly invite any of these municipalities, West Cornwall, South Lebanon, South Anvil, if they're interested in joining with us and forming a multi-municipal planning agency, please contact us. We're interested. As far as the sliding scale goes, I think it's important for people to understand that the sliding scale has been tested all the way up through the Supreme Court. It's the only defensible, one of the only defensible methods that's been judicially reviewed, which is one of the reasons that's the method that we had chosen to limit, not eliminate, but to limit growth in our agricultural zone. You know, you've heard some talk tonight that maybe it's not enough, and certainly there are some neighboring municipalities whose sliding scale is more restrictive than ours. There's certainly some in Lancaster County. In fact, it's my understanding that ours is probably the least restrictive of the sliding scales in the county, and certainly one of the lesser restrictive ones in Lancaster County. Maybe we need to change that. I've always looked at zoning ordinances as documents that evolve over time. I think that they need to be documents that change over time. If they're just an open and shut book, you open it, boom, we're done, and we never revisit it again, I think that's a dangerous thing. And I don't think it's a healthy thing for a community or for a municipality to function that way. So I would suggest that not just this particular zoning ordinance, but all the ordinances that we have need to be looked at carefully, studied. I fully expect that over the course of the next year that we're going to be here in front of you with other amendments, looking at other parts of our zoning, you know, and we're going to continue to move forward, not without public comment. I fully intend to go back and meet with the farmers, to work with our planning commission. I don't feel that this ordinance is done yet. But I think we've taken some huge strides forward compared to what we have currently. And I think we need to make changes in a lot of areas. So, but with that said, I think it's important that I correct two of the things that were said tonight, because I don't think it reflects properly the actual circumstance. Bill, do you have anything?
Yes. As Mr. Myers spoke about the sliding scales, I'm also in support of the sliding scales. The only major concern that I have here is Section 13, which Mr. Myers also spoke about. Or Section 3, I'm sorry, which is eliminating the public elementary schools, municipal buildings, churches, and cemeteries, private nurseries, elementary and high schools, and institutions of higher education. I think in an agricultural district, higher education can include research and farming. I think that this section needs to be revisited by the Planning Commission and sent back to us. Just Section 3 and 4, which also, I think every individual item in that section needs to be revisited by the Planning Commission.
Thank you. Anything else? One thing I would say is an opposing point of view, and I'm not necessarily disagreeing with what Bill said, but that at some point you have to consider whether or not you're actually preserving agriculture. And if you are, then you have to consider what rights should be allowed, or what uses rather should be allowed by right. You know, and that's where this whole issue with churches and schools and all the rest comes into play. It doesn't mean that you can't develop some of those things within your ag district. And you're certainly not restricting those things within North Cornwall Township. There's certainly lots of other places that we can put schools in our R1 and our R2 and other areas. It's just the other side of the coin, I guess. And then talking to other planners and other solicitors, and a point that was made to me was, you know, you got to decide what you're doing. Are you trying to preserve your ag lands? Do you want to maintain a viable agricultural community or not? And if so, then you need to really carefully look at what uses you're going to permit by right. So, something again that maybe we need to take a look at and consider down the road.